listening to Estate at the Union, estate planning made simple. Here's your host, Brad Wiewel, from Texas Trust Law in Austin, Texas.
Hi, this is Brad Wiewel with the Estate of the Union, and this is the podcast of Texas Trust Law. We talk about legal issues, we talk about movie reviews sometimes, and occasionally we have guests. And today we have, as a guest, Sam Bassett, who is the best criminal lawyer in Austin, Texas. And I think, Sam, I'm going to take you out to Central Texas, and then I think I would just go statewide. So Sam is the best criminal lawyer in the state of Texas. That's a big statement, but it's true. And criminal lawyers, I know, well, they just deal with criminals and they're all guilty and blah, 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 blah. Right, Sam?
Right.
That's what you hear every day.
Yes.
Your friends, and how can you do that? We're going to ask Sam how he does that. We're going to ask Sam about how to keep you out of trouble, how to understand more of the legal process. And so, Sam, if you're ready, let's get going.
I'm ready to.
Okay, let's go. How long have you been a lawyer?
35 years this November. So.
Okay, there you go. So lawyers get licensed in November, and yeah, I was licensed many moons ago too. But what got you interested in criminal law?
I think from the time of being young, I was always interested in criminal cases, criminal TV shows, how we treated people who were accused of crimes, prison movies, things such as that. I just was drawn to that for some reason, and that was kind of my initial spark in junior high and high school.
Okay, all right. The TV representation of defendants, because you're always in the defense. The prosecutor is always the kind of the plaintiff. If it's a civil lawsuit, the prosecutors would be the plaintiff. You'd still be the defendant.
Yeah.
But the question that a lot of people ask you, I'm sure, and my clients, how can you do that? If you know somebody's guilty, how do you defend them? And I'm going to use the word if they're alleged to have done this, because the key word there is alleged, right?
Right.
Okay.
Right. I think one of the concepts that you buy into if you become a criminal defense lawyer is the system needs protection. The individuals that are in the system need protection from the reach of the government. Because when a situation involves someone's charged with a crime, you begin to understand when you're a defense attorney how much power the government has over an individual who may not have any resources, or who certainly doesn't have the resources to match the government's resources. And so one of the things we do is we're essentially constitutional referees for the individual in our country who is charged with a crime. That can be an individual who is obviously guilty. It could be an individual who is obviously innocent. And then there's everything in between. And oftentimes I'm dealing with very guilty persons, and the issue is, what is the punishment going to be? What is the sentence going to be? What is the consequence going to be for somebody who violated the law? Other times I'm representing somebody, and this is the more stressful situation, where you believe and you find that they are obviously innocent, but the government won't relent, and the government continues to go forward. So in terms of representing a guilty person, sometimes it's mitigation of consequences, and sometimes it's just making the government live up to their constitutional duty to prove guilt beyond a reasonable doubt. It is a rare instance when you have somebody who you know is guilty and you find a flaw in the case and they walk out of the courtroom. But it does happen sometimes.
Sure.
So you have to have a little bit of a commitment to the ideal. And the ideal is nobody should go to prison or even be put on probation and convicted of a crime unless the government can prove their case beyond a reasonable doubt.
Let's talk about that beyond a reasonable doubt. So, viewers, there are basically three standards of proof in the law. One, if you're in a civil suit, it's a preponderance of the evidence. So if I've got, we're arguing over something, some lawsuit over some money. If I can prove by 51% likelihood that I'm right, then I should win that because I have the preponderance of the evidence. The other standard, the next standard up, is clear and convincing.
Correct.
Right?
Correct.
So clear and convincing is more than a preponderance. You've really got to have the goods and show the goods. And in a civil case, there are some civil statutes and lawsuits that require clear and convincing evidence. But beyond a reasonable doubt is the highest burden, and it's called a burden of proof that's on the state or the federal government to prove that this person, you perhaps in some situation, committed this crime. And then again, we'll talk about punishment. So it's a lot.
It is. It
and
is.
then you talk about the government resources and the resources you've got. Well, sometimes you do federal crimes too, I'm
Yes.
sure. So now on the federal side would be the FBI, I presume, or
Yes.
the DEA or whatever.
Right. Right.
They got a lot of people.
Yes. ATF, Secret
Sure.
Service, U.S. Attorney's offices. Yes.
How do you fight that?
It is hard.
I bet it would be hard.
It is hard because typically, especially in a serious federal investigation, you have a situation where they may have investigated somebody for years before you ever get involved. And then all of a sudden this person calls you and says, hey, I got a knock on the door from the FBI. They busted down my door, grabbed all my computers, shut down my business. What do I do? And here you are, you're playing catch up.
You're sitting in your office,
Yeah.
and this call comes in.
Yes, yes. And you're like,
Right.
okay, we got to marshal some resources to try to figure out what's happening. But it's a very tough disadvantage for somebody who's been investigating the case versus you, who just have met the person an hour ago. So it's really a tough battle to undertake, but discovery is required. They're required to disclose information to the defense. And oftentimes some federal prosecutors will hold back until the last minute in disclosing information, and you have to ask for a continuance. You know, the most extreme example I've seen in my career is the January 6th defendants. I represented one of them. He pleaded guilty to a misdemeanor.
This is the Capitol
Right.
riot or invasion, whatever it was.
Right.
All
So some of the more seriously charged defendants, my guy was ultimately given a misdemeanor in probation, but the more seriously charged defendants have terabytes and terabytes of discovery because of all the audio-visual surveillance. So that's an extreme example of the amount of information you have to cull through to try to determine if you have a defense or what your defense might be.
Wow. Okay. That's
a lot.
That's a lot. Well, that sure is a lot. So you brought up something, Sam, that again I think our viewers, listeners would like to know more about, and this gets a bad rap too. Seems like everything criminal law on the defense side can get a bad rap. But that's plea bargaining. Okay? And I got off with probation, and you should have gone to jail for 150 years or whatever. Share with our audience what plea bargaining is and why the prosecution would ever cut a deal, and what sort of thing you might be looking at in that setting too.
I would say that the plea bargaining system that's been in existence for 50, 100 years in this country falls under the umbrella of limited resources. Not every case can go to trial. As a matter of fact, the system can really only afford for 5 or 10% of the cases to actually go to trial. Otherwise, it would come to a grinding halt.
Because there's only so many judges.
Correct.
And only so many courtrooms.
Correct.
And so many people available for jury duty.
Exactly. And only so many law enforcement.
Sure. So many prosecutors, so many defense attorneys.
Right.
Okay.
Right.
Sure.
So under that umbrella, you have cases of a different nature. You have the really serious cases, the murder cases, the sexual assault cases, the child sex abuse cases. Those are generally given higher priority. In the federal system, you have the conspiracy, the big
drug cases.
Yes,
Sure.
big drug cases. And so there's a limitation of resources, and the two sides have to quarrel a little bit. And the factors that I think go into a plea bargain are the government has to look at the strength of their case. How strong is their case? But also what we spend a lot of time doing is what we call mitigation evidence. We try to humanize our client to the prosecutor.
Sure.
Get them help.
Okay.
If they have a substance abuse issue, if they have a bad, tough childhood background, we try to explain to the prosecutor how it is that the person could have gotten involved in suspicious activity from the point of view of their life story.
Because you're also they know you're going to explain this to the jury and try to get something from the jury.
Yes, and you're also trying to persuade the prosecutor, because the prosecutor is sitting there with 100 cases, and they can only try 5 or 6 of those, and they're trying to figure out what case am I going to try. So the seriousness of the crime, the strength of the case is on one side of the teeter-totter, and the other side of the teeter-totter is what kind of person is this? Is this a person who has a lot of criminal history, or or does he have a bad childhood background? Has he sought help since he got arrested? Does he have a substance abuse issue? Those sorts of things.
Right, so you can humanize them and then again, let the prosecution know that they're probably not going to go out and commit another crime, which would be helpful in your case.
Right.
And this is why we need to give them probation or a shorter sentence, I presume.
Right. And then we have the conversation with our client. Okay, if we go to trial, here's what could happen. This is what they're offering you. And then the client has to make the decision.
Sure, because it's their life ultimately that's going to happen. Yep. And yeah, okay. Well, we've all, I think, maybe you've seen a prison movie or two, and you've seen a lot, and I've seen a lot, and they're interesting stories. But yeah, I don't want to go to prison if I don't have to.
Right. Prison is not where you want to be.
No, I would think not. So, you've been practicing law again 35 years, I think you told me. What's the most interesting case you've ever had?
You know, I think of 5 or 6 cases, some of which have gotten media attention, but a case early in my career that really shaped my perspective was a case out in West Texas where I represented a grocer who was married to a young lady, and they had 2 children, and then they divorced, and they were having some custody battles in court. And in the midst of that, he was accused of sexually abusing his children, his young children. And it was in a smaller jurisdiction in West Texas. He was well known. I believe he was singled out by a DA who didn't like his family. And then we went through the process, a 3-year process, where he had to have 2 jury trials.
Wow.
And the allegations were very extreme and bizarre. We did a lot of investigation. We entered an appearance in the family law case. We took depositions, which is a luxury we usually don't have in a criminal case. And we basically took apart the case of the CPS had put together against him.
CPS is Child Protective Services.
Correct.
All right.
And so we ended up, he was acquitted at his first trial, and ironically, as he was hugging me, and we were happy that he was found not guilty, he was rearrested in the courtroom right after the not guilty verdict was returned. So then we had to bond him out, and then 6 months later we had a second trial. He was again acquitted by the jury.
Wow.
So that was a very interesting situation.
That's a hard deal. That's such a hard deal.
A very serious allegation, and he luckily had the resources of his family who allowed us to be able to do what we needed to do.
To pay for all this.
Yes.
Right? Because this is expensive stuff. Sam, I think you sold that Yugo you were driving a while back.
Yeah.
And, yeah. No, these are expensive things, and that's part of the stress, again, on the defendant side, which is why you have a whole public defender appointed lawyers. How does that system work in Travis County, though?
Well, Travis County has evolved. In the last 10 years, we've developed a more extensive, fair-minded public appointment of lawyer system. The first was called CAP-DS, where we had a system where certain lawyers signed up and were screened, and then they were assigned to
represent
defendants.
indigent defendants.
Yes.
Okay.
Now we actually have a public defender's office to work with CAP-DS, where you have full-time lawyers who are part of the public defender's office.
Okay.
And that system probably absorbs anywhere between 20 and 40% of the criminal caseload now, because so many people can't afford lawyers who are in the system.
Sure.
And so Travis County has really improved its system. It used to be the judge would just pick out some people who had volunteered to be appointed, and what we found was oftentimes judges were picking out the same lawyer over and over again because that lawyer got their case resolved quickly.
Sure. And they knew them, and they were buds, and all that stuff too. Sure.
It's a lot more of a balanced system now, in my opinion. And the data show that when you have a rigorous public defender program, the outcomes are generally better because they are better trained and more committed to their clients in terms of defending them.
And they're not, again, necessarily looking for a quick out. Right. Sure. Wow.
Yeah.
Okay. Well, I've got another zinger of a question.
Okay.
All right. So, and this, again, may be something that we hope never applies to anybody here, but it could apply to anybody here. And this is, my wife and I go out to dinner tonight, and we have split a bottle of wine. Well, I end up drinking 3 glasses. She drinks 2 glasses because she's only a 2-glass girl, and I can absorb 3. I think I'm not the thinnest person on the planet.
Right.
And we're on our way down Mopac, and I get stopped by a police officer, and he wants to give me a field sobriety test, or he's asking me questions. It's not uncommon, and you've done your share of DWI cases, right? So in Texas, by the way, ladies and gentlemen, we don't call it DUI, which is what other states like California might call it. We call it DWI. That's, what is that? Driving under the
while
influence.
intoxicated.
And this is driving while intoxicated. The W is Texas, by gosh, all right? So I am stopped for potentially a DWI. What should I do?
Well, it's a judgment call. What I advise people, generally speaking, to do is if you've had more than just a little bit to drink, it is probably the wisest thing. Obviously, first of all, I tell people to be very polite to the officer.
Okay.
They have a tough job.
They do have a tough job.
When they're
don't
walking
they?
up to a car, they don't know what they're going to face.
Right.
Are they going to face somebody with a gun, or with somebody who's going to do something crazy, which happens 5% of the time.
Sure.
Dealing with somebody
Sure.
who's really
Sure.
crazy. And so be polite. Make sure the officer understands you're obeying him or her. Your hands are visible.
Typically, don't get out of the car.
Right. Keep your hands on the steering wheel. Be very polite. Provide them your license, your information. But I think that there's a point at which they will ask you if they smell alcohol in your breath, or you admit to having consumed alcohol, to perform field sobriety tests.
Should you admit to having consumed alcohol?
I think it is okay, in my opinion, to admit to some drinking.
Okay.
But if the questioning goes beyond that, I typically tell people to politely say, I'd like to talk to an attorney before I answer any questions.
Okay.
Now, if you've had a smidgen to drink and it's been several hours and you absolutely have no hesitation that you're under the legal limit, that there might be an exception that I would advise in that circumstance. So
Okay.
if you had a beer 2 hours earlier and nothing more for the last 24 hours, and you have no doubt that...
And you have no mobility issues either, right?
Right.
Because they're
Right.
going to videotape you walking in a straight line,
Right.
Standing on one foot, I guess.
Right.
I don't know what else involved.
They test your eyes, your eye movements. They usually do a walk and turn test and a one-leg stand test. Those are kind of the standardized field sobriety tests. I think that I might have trouble doing some of those tests right now. And
I might too.
I haven't had a
I might
drink
too.
in
Right.
2 days.
Right.
So those tests are designed to test a normal, whether or not you have normal use. In fact, the tests are not normal at all. So I'm very cynical about those tests. And then they'll follow up usually with a question, well, will you consent to a breath test? Will you consent to a blood test?
Okay. Now, can I say no?
Yes.
All right.
Now, if you say no, in some jurisdictions, in many jurisdictions now, they can get a search warrant to draw your blood at the jail.
Okay.
And you cannot, there's nothing you can do about that.
And those no refusal weekends, so probably this is a no refusal weekend. We're here on Labor Day weekend of 2023. That's typically what they do around holidays, I guess, because people tend to drink more. So if they take me downtown to have a blood draw to see where my blood level is, I can't refuse that because they have they must have like a magistrate or a judge that are signing an order for the search warrant, just boom, boom, boom.
Right.
Okay.
Now, the search warrant has to contain probable cause.
Okay, that's
so
interesting.
that's a challenge that can be made later if,
All right.
if they didn't have sufficient facts to believe that you were intoxicated.
Okay, so you could still perhaps beat that.
Right. But the blood draw typically will happen 1 or 2 hours after the stop, and that's done at the jail, and occasionally they've had to tie people down to draw blood, which is not ever anything you want to be part of.
I don't think I want to be tied down
Right.
while they draw blood.
Right.
No, I don't think so. And I don't want a broken needle in my arm or any of that stuff too. So
Now, there are some lawyers that advise do the breath test. Do the breath test if you haven't had much to drink, because the breath test is easily challenged. The blood test has a little more rigorous science behind
Sure,
it,
sure.
but it's also challengeable. Gas chromatography is the science they use to extrapolate results in a blood test, and then the breath test is a lot more of a loosey-goosey science behind it.
So, thanks for that. I mean, that seems like, again, for our viewers, listeners, the most likely way that you're going to end up in a criminal setting would be, again, a bottle of wine, the 3 glasses instead of 2.
Right.
You're pulled over, as opposed to me going out and murdering somebody. Probably, I've thought about it, but I would never do it. But yeah, so this is, I mean, again, it seems like
Right.
the most common crime anybody can
Sure,
end up
that's
with.
definitely a offense we see often in our office. There used to be DWI interdiction units that were out patrolling the streets. Now we have a shortage of law enforcement in Austin, so that's less common, but it is still out there.
So do they do, I've heard some states they can do like road closures and test everybody coming through. Do we have that in Texas?
We do not. There
Okay.
have been some proposals to do that over the years, but they've never gotten through the legislature.
Okay, all right. Sam, any other more common crimes that you see people accused of? And again, I'm going to use that term accused of because people think, by gosh, that if they're arrested, they must be guilty. Not so, again. Any other more common criminal matters you see
I would
people fall
say
into?
there's two categories.
Right.
One now is obviously possession of drugs.
Oh,
and
sure, of
now
course.
that THC, cannabis, is arguably legal in most places in the country, there's that common crime now of, okay, THC oil, is that illegal? Each county has a different philosophy on that. It's strange.
Oh, is that right? Huh.
Yes. So in Austin, in Travis County, typically those cases are not prosecuted, or if they are, you're easily diverted into a diversion program where if you do certain things, the case is ultimately dismissed. Now, if you drive 20 miles to the northwest to Burnett County, that is going to be prosecuted as a felony and is not likely to be dismissed, and you're likely to have to deal with a felony probation on your record.
Wow.
So it's
Isn't
interesting.
that
Within
interesting?
Texas, there's such a divergent view about the issue of cannabis and THC.
And again, there's lots of people out there that are token away and
Right.
or that go, I mean, I'm sure there's a steady stream of cars to the Colorado border
Sure.
and probably New Mexico too.
Yep.
I think they may have it legalized out there too, but it's not legal in Texas.
Right.
So be
Right.
careful about that and
Yeah.
don't just think that, boy, howdy, you're a wink and a nod.
Right.
Okay.
Right.
All right.
Now, another common offense that happens, maybe not as common as the THC cannabis issues, domestic violence. You have average
Absolutely.
people who get into an argument. Somebody decides to call 911, and it's been pushing and shoving. It may not be as extreme as many cases, but the police are under extreme pressure to arrest somebody.
Because of the social nature of the crime.
Exactly, and
Sure.
the worst thing that could happen is they leave the people together, say, we're not going to arrest anybody
Right.
because you guys say you're calmed down, and then an hour later something really bad
Somebody's
happens.
dead or whatever.
Yeah.
Right.
And so there's a lot of pressure in those cases. And so you have everything from the very extreme domestic violence cases, which are obviously prosecutable and convictable and arrestable, to the more, a couple that hasn't had any prior issues, has something happen.
Again,
and
they've
one
been
calls,
drinking, smoking,
right,
whatever. Right.
One calls the law enforcement, and it's sometimes the law enforcement will say, we're arresting him or her, regardless of what you say, because of what we learned about what happened.
Okay, all right, and then again, now we're in court and call you, and what is your number?
Oh, the number at my office?
Yes,
It's 512-476-4873.
512-476-4873.
Right.
All right, this is Sam Bassett. So if you got a problem, you taking new clients?
Oh, yeah. We have 9 lawyers, so
Okay, there you
we're
go.
busy.
There you go. There you go. Yeah, we have 6, and you get this many lawyers going. It's always something too.
Yes,
It's
yes.
we have our own little personalities, and it can be fascinating.
Yeah, yep, yep.
I'm going to ask one more question. Again, I think this is of interest to our audience, and it's common. It's a little. Maybe I'll ask 2 more questions. The first question is: you hear about people getting indicted. All right, let's pick on President Trump. President Trump has been indicted on this. Does that mean, and I'm just picking on him, anybody gets indicted, does that mean they're guilty?
No, absolutely not.
Tell me what that means.
As a matter of fact, a court instructs a jury you can't consider the fact that somebody's been indicted and evaluating whether or not they're guilty beyond a reasonable doubt.
Okay.
An indictment is a grand jury process in which citizens from the community get together and prosecutors present evidence to prove probable cause to believe that they committed a crime.
This is all evidence from the prosecution side.
Correct. Very rarely does a defense attorney get to present anything to a grand jury.
Okay.
And if I send my client into the grand jury, I'm not allowed to go in with him or her.
Huh.
And so I've done that maybe 3 or 4 times in my career where a client went in and testified. And it's nerve-wracking because I'm sitting outside.
Sure.
That person's under oath with the court reporter there with 2 prosecutors, and the grand jury can pepper them with questions. So it's a very one-sided process. But the grand jury ultimately determines, do we believe there's probable cause to believe that this person committed a crime based on the evidence the prosecution has presented to us?
Without seeing any defense evidence at all?
Correct.
Okay.
Correct.
So you're not guilty. You've been charged
Right.
with a crime, and that's as far as it goes.
It's a threshold that was, in the old days, it really was kind of a screening mechanism. But today it's become much less of a screening mechanism and more of a formality for prosecutors to use to get somebody indicted. You've heard the saying, a good prosecutor can get a ham sandwich indicted. Well, there's some truth to that.
I've heard a good prosecutor can get an innocent person convicted. I'm
Yes.
sure they can
Yes.
too.
Yes.
All right, let me talk about one more topic then. Again, that has certainly a fair amount of mystery to it, and that's probation.
Yes.
All right, so I got probation. What does that mean?
Probation is the term that everybody understands and hears. We now in Texas call it community supervision.
All right.
The idea behind probation is that somebody is convicted or pleads guilty to a crime, and instead of putting them in jail or prison, we put them under the supervision of probation departments.
Okay.
And the probation department monitors them, both in terms of making sure they don't commit any other crimes, making sure they're not using illegal drugs or alcohol, and also just monitoring their progress with counseling if that's required. Community service work also can be required, and random drug and alcohol testing can be part of it.
So you have kind of more than a guardian angel. You got
Yes.
somebody who's keeping track, keeping records
Right.
of your hitting certain goals or achieving certain results,
Right.
whether it's so many counseling sessions or community service or something
Right.
like that.
And in today's world, we have technological devices that can be used on probation, such as GPS monitoring, such as a continuous alcohol monitor on your ankle, sometimes blowing into your car before starting it, and also sometimes while you're driving it to make sure you're not consuming alcohol while driving. So
Oh, wow. So you can
there's
do
a lot
that
of
while they're driving. You have all this new tech stuff,
Yep.
too. All right, so I'm going to, the last question, I promise. But
Yeah.
still, it's a common thing you hear about. So you hear about probation. So probation is where, and then that's usually going to be probably part of a plea deal.
usually.
Yeah, where you're not going to go to jail, but you're going to be on probation for 3 years, 5 years, 6 months. There's another term that everybody has heard about, and it's parole. All right. Now, I know the difference in probation and parole, but most of our audience, what's the difference in probation and parole?
Parole is a supervision in the community after you've served time in prison.
Okay.
And a parole officer is different from a probation officer, but there are similarities.
So if I'm out so I've done my 5 years of a 10-year sentence. They let me out earlier, going to put me on parole for the 5 years that
Right.
otherwise would have served. Same kind of deal, though. Now I have a parole officer. I have to report to, monitor my goings and comings.
Yes, the conditions are a little less rigorous than probation.
Oh, is that right?
Yeah.
Huh, okay.
I think drinking is allowed so long as not to excess, and I do think you have a little less in supervision. Now, there are certain crimes where parole is very strict.
And these are
Sex
gonna be,
offenders.
Yeah, I was going to say sex offenders.
Violent offenders.
Sure.
They might be more rigorously supervised. But if it's a drug case or a theft case or a case not involving violence or sexual violence, it will be less rigorous than your probation supervision.
Okay, very good, very good. And if I violate probation, if I violate parole, then I can go back and have to go back to jail.
Yes.
Go to
Yes.
jail the first time if I was on
Yep.
probation. Okay,
Yes.
all right. Wow, it's a lot of stuff.
Yeah.
This is really good stuff.
Yes, thank you.
It's mysterious again to, I'm sure most of our listeners and viewers, because we just see it on TV or we hear about it online and we read some news story, but to know kind of the sausage-making role that's going on back there has been very helpful too, Sam. So before we wrap up, Sam, what's that phone number again?
It's 512-476-4873, and the law firm is Minton, Bassett, Flores, and Carsey.
Might want to write that down just one more time.
512-476-4873.
Great, great. Thanks for coming. Wow.
You're welcome.
So we're going to wrap up this edition of the Estate of the Union. This is Brad Wiewel. I want to remind everybody that our phone number is 512-480-8828, 512-480-8828. If you need to come in or want to come in to talk about a will, a trust, somebody's passed away, you need to do a probate. We do special needs planning for clients that have special needs loved ones. We do elder law planning for families who have a loved one who has run out of money and they're getting sicker, and we need to do something to preserve some of the estate for the family and get mom or dad the care they need. That's called elder law. Our next guest, Wade, is going to be a judge, so we'll have her on here sometime soon too. So have a great Labor Day weekend, and by the time this shows, Labor Day will be long gone, but have a good weekend, and thanks, Sam, for coming.
Thank you.